Good afternoon, everyone. Thanks for joining us today for the webinar, 5 Elements to Conducting a Successful Workplace Investigation. Before we get started, I do just want to go through a couple of housekeeping things. All phone lines are muted. If you have any questions throughout the webinar, please feel free to type them in using the questions or chat feature. I will address all questions that are posted up during the webinar at the end. We will have a Q&A portion at the end of the webinar, so feel free to hold them till the end or just pop them in as we go through. This webinar will last about 30 to 45 minutes, and then we'll save those last 15 minutes for questions. You will receive a copy of the presentation within a few days, along with some additional resources. And at the end of the webinar, we would appreciate any feedback that you have, so please respond to the post-webinar survey and follow up. Take a look at our website. We have a lot of other webinars coming up, and we'd be happy for you guys to continue to join us. A little bit about myself before we get going. I am the Manager of Professional Services and Behavioral Science Specialist for Business Controls. My area of expertise are in conducting corporate investigations, conducting threat assessments for workplace violence incidents, as well as providing corporate trainings. I conduct trainings in this format of webinar, as well as private trainings for organizations, on-site instructor-led trainings. A little bit about our company. I work on the professional services side, which, as I stated, is conducting investigations, doing trainings, and providing background searches and due diligence research. Business Controls also is a provider of incident reporting and case management software. It was founded in 1994, and we currently have clients in over 22,000 locations and 130 countries. Prior to joining the team here at Business Controls, I was conducting threat assessments, psychological assessments for criminals after they had been convicted, but prior to sentencing. I very much enjoyed working with criminals in that realm, but it had quite the high burnout rate. So when I had an opportunity to focus over in the corporate realm, I jumped on it, and I'm very happy doing this type of work. Let's go ahead and get started with today's presentation. I'm going to begin with defining investigations and the difference between public and private sector investigators. We'll then move into discussing the 5 elements to have in order to have a successful investigation, and we'll follow up with how to properly document evidence and report your findings. Defining investigations. So this section we're going to focus on the difference between the private sector and the public sector. There are many different definitions for the word investigation. If you do Google searches, a lot of different things will come up. The word investigate actually has Latin roots and means to search into. So that's where we are at the most basic definition. You'll notice some other general definitions on the screen. I tend to default to definition that was authored by one of our co-founders here at Business Controls. He defines investigation. The process of investigation is dynamic and fluid. The approach must be reasonable and the investigator flexible. However, in order to be successful, every investigation must have a meaningful purpose and be executed ethically and lawfully. Taking that definition into consideration, we're going to kind of dissect it as we discuss the differences between the public and private sector, and then you'll notice that we really outline the 5 elements to mirror this definition that we have of investigation. All right, public versus the private sector. Although the tools and techniques and processes are pretty similar between the public and the private sector, there are differences. When we refer to public sector, we're generally talking about law enforcement, so the police. They're conducting their investigation according to the enforcement of public law. Private sector investigations, that's where we're really sitting with the corporate investigations, they're conducted pursuant to the needs of the organization within which they are performed. There can be overlaps between the private sector and the public sector. However, the private sector very rarely has that law enforcement powers. Private sector doesn't have to comply with the due process rights that the public sector has to. Do want to keep in mind that while there may be overlaps, so for example, you could have an employee who engages in perhaps taking company material. There can be the overlap into the public sector, considered theft. While your organization may want to flip over that type of an investigation to the public sector investigators, we would always recommend, regardless of what kind of criminal act it may be, that you first conduct your internal private investigation, reach your own conclusions to determine whether there is a violation of policy, and take any disciplinary action needed prior to flipping it over to the public sector. It's important that you're conducting your own independent investigation so that you can reach your standard of proof, which is much lower than is required in the public sector. The only exception to that is involving child pornography. So if you do have an employee, most frequently this is coming out on computers, that is engaging in looking at that type of material, or distributing that kind of material, that is something that you need to immediately report to law enforcement. But anything outside of that, you're absolutely within your realm to conduct your own independent internal investigation first. And oftentimes when you try to get the police involved, they tend to flip it back to the organization, referring to it as a company issue. So again, our recommendation is just go ahead and handle it first internally, and then if you want to go the police route or the prosecution route, follow up after you've reached your conclusions. So not only are the methods in which we conduct investigation different, even the terminology we use is different. I have some examples here of the differences. Some common words to use: the police often use the word suspect. When they're looking for an accused individual, we'll refer to that as the subject or the alleged wrongdoer. I myself am not an investigator. I'm a fact finder. We do not interrogate individuals. We interview them. We generally will not refer to our complaining parties as victims. We call them the reporting party or the complainant. So as you can see, these words, to some it's just semantics, right? They're basically meaning the same thing, but the private sector's verbiage is much more soft. So as you can imagine, an employee coming into a room, if you identify yourself as an investigator and you're conducting an interrogation, first identifying yourself as a fact finder and you wanted to interview them to see what information they have, could be perceived by the interviewee as two totally different ways. So we just like to soften our approach and try to distance ourselves from the image of a public sector investigator or a police officer. Sometimes during the initial disclosures during an interview, I'll even explain to the individual who I'm not to continue making that distance. So I will explain that I'm a third-party fact finder and that I'm here to gather information, and I want to make it clear that I'm not the police. I'm not associated with the police. Rather, I'm an internal fact finder who's here to gather some information. So taking that approach can often start you off on a better foot and help you build the rapport with the individual during that interview. A couple of other differences or things that are accepted by the public sector but not generally accepted by the private sector. These are the main ones: lying, making promises, or threatening. In general, those practices are largely accepted in the public sector and are not accepted in the private sector. It is unacceptable to lie to an individual or to make promises. For example, it is not acceptable to say, well, if you're truthful and honest with me here during this interview, we will not turn this information over to the police. Or if you come clean now, then you won't receive any disciplinary action. Making those kind of promises are unethical and, quite honestly, generally you aren't even in a position to be making those promises during the interview. We recommend that the individual who is engaging in the fact-finding is different from the individual who's actually making the decision. So as a fact finder, you really shouldn't have insight into what the outcome is going to be, and you shouldn't have influence into that outcome. So we want to make sure to not engage in any of those behaviors. We also don't threaten or coerce anybody that we're interviewing. That is definitely unacceptable and can be considered unlawful and get you jammed up in the courts as an interviewer. The threatening also can often lead to false confessions, so it's another good reason, besides the fact that it is completely unethical. We want to make sure that any admissions that we're getting are accurate and not false. So don't threaten anyone and you'll be safe. Obligations of the employer. An employer has several different obligations, may have different obligations to investigate. We have moral obligations, statutory obligations, as well as financial obligations. So statutory obligations most commonly are going to fall under the Civil Rights Act, or OSHA. As far as Title VII, 1964 U.S. Civil Rights Act, does require that employers investigate all reasonable allegations of harassment or discrimination based on any protected class. So under the Civil Rights Act, you absolutely have a duty to investigate any of those reasonable claims. Also under OSHA, you have a duty to investigate claims that are related to any hazards in the workplace that are likely or are causing any kind of physical harm to the employees. There are other federal and state statutes that may also require an employer to undertake investigation, so you need to be sure to be updated on all those state and federal regulations. You may have a moral obligation to conduct an investigation. So I have an example which may fall under moral as well as financial. A property management company, we conduct fraud investigations for property management company. They'll come to us when they have an individual that they suspect may be engaging in fraudulent behavior. We conduct analysis on their record keeping and on their books and make a determination of whether or not we're able to find any patterns of engaging in the behavior. In this particular case, there were a lot of red flags. So we saw, looking at income statement records and things like that, we noticed a big difference between what was going on in 2011 versus what was going on in 2012. For example, it seemed that in 2011, the property manager had given something like $1,500 in concessions to residents. Then in 2012, that number was more like $20,000. So a huge difference there. So where is all those concessions coming from? While we don't have anything to directly prove that the individual was pocketing that extra money or where it came from, we do have residents saying that the property manager was accepting cash. So kind of putting the two abstract thoughts together leads us to conclude that the property manager is likely engaging in fraudulent behavior and pocketing that cash that he is receiving. When we reported that information to our client, they're now in a position where I believe they have a moral and financial obligation to continue investigating at a minimum, and definitely to notify the owner of that complex that they may owe the owner some money. At this point, it's definitely on the organization, the property management company, to make that determination. It was certainly our recommendation to, at a minimum, keep investigating, look at a couple more documents, maybe contact a couple of residents, and interview the property manager to see whether or not we could get an admission. I should find out shortly what they're deciding to do. But that's just a good example of falling in a moral obligation. You know, do they feel comfortable looking at that owner in the eye and saying, you know, we don't believe that he stole any money? I wouldn't feel comfortable with the information that I have, but that's up to the individual company of where they sit on it. Moving into 5 elements of a successful investigation. We're going to review each of these step by step. First one being management commitment. Second is meaningful objectives. Third, well-conceived strategy. Fourth, properly pooled resources and expertise. And fifth, lawful and ethical execution. All of these elements are required in order to have a successful investigation. First, commitment. Failure to have one or more of these commitments will almost always result in a failed investigation. From the very beginning, the organization and the decision makers must be prepared to commit the time, patience, and resources in order to achieve its objectives. Before the investigation starts, it's important to make sure that everybody is on board. Oftentimes we'll have the main decision makers on board. So we have HR, legal, compliance. Those types of individuals understand what an impact an individual can have on an organization. When it filters down to the management level is sometimes where we can get the pushback, or most often we're seeing the pushback. Frequently you'll have a manager whose employee is really good at hitting the numbers. They're really good technically at their job, and so they're willing to overlook inappropriate behavior. We cannot have that. We've got to set the tone right from the beginning. So you need to make sure that you've got management in on it, that management understands. If the investigation ends in confirming that somebody engaged in whether it's unlawful or inappropriate behavior or violation of policy, you need to have them buy into the fact that they're going to follow through with any recommendations the decision makers have. If your manager isn't on board, even though they may enact some discipline or something like that, if they're not fully in support for behind it, the message may be skewed. Your employee may not get the message that the decision makers want, and it's likely that the behavior is going to continue. So be sure to meet with everyone, even if the manager is not part of the decision-making team. He or she should be brought in at some point before the investigation starts, and have that manager make a commitment that they're on board and that they trust the organization and will support them in whatever decision or outcome they might have. These managers are also need to be patient and willing to give their time. Investigations can be extremely disruptive to the workplace. It's always our goal to be as least disruptive as possible, but sometimes you have to pull people off the floor. Sometimes people are going to have to miss meetings, and that's just the way the timing of it goes. So we want to make sure that the managers understand. We will do everything we can to adjust our schedules as the fact finders to be as least disruptive, but at the same time, we need management's commitment to us that they're going to set the time aside and allow their employees time to come speak with us. Second element is having meaningful objectives. So we refer to these objectives as universal. These are something that we include in all of our written reports. We want to make sure that it's very clear of what our objectives were at the beginning of the investigation. So these should be able to apply to any investigation. First thing you want to do is identify the true nature and scope of the problem, determine who was involved and why. It is never our goal to prove an allegation or to disprove an allegation. At the onset of an investigation, all you ever have is an allegation. It's our job to take that information, identify the true nature and scope of what was going on, and seek out who was involved and why. That'll help us make a good decision. We are never out to just prove or disprove something. That will truncate our investigative process, and you will get hit on that in court if you're not taking a more broad approach. You also want to collect the information necessary to allow for the proper distribution of disciplinary or corrective action when that's appropriate. What we mean by that is that we are constantly reviewing the policies and past practices so that we're collecting the information such that we're either confirming that there was a policy violation or that we're somehow acknowledging that somebody engaged in behavior and then are able to link that behavior up to a particular policy. So we always want to be able to go back and link it up to some kind of policy that we have written down. Want to execute the investigative effort such that it is least disruptive to the organization. Kind of went over that one in the first element. And then the final one is achieve the best possible return on investment. So this one is twofold. As a third-party investigator, it's really easy to put this out there. So it's always our goal to get the most sound conclusion in the least amount of time as possible. We're typically being paid on an hourly rate, and so that's what we mean by best return on investment. This also applies internally. Your time, you're being paid for your time as an investigator, so you want to be able to draw conclusions as quickly as possible. So that means we're not going to over-investigate the case. We're going to talk to as many people necessary so that we can come to a reasonable conclusion. We're not just going to keep talking to people because they were identified as witnesses or because our complaining party thinks it's someone we need to talk to. We only speak to those that we need to until we can reach our sound conclusion. Objectives can be a little bit more specific. So generally in our reports, we're going to have most of these universal objectives, but we might get a little bit specific. So identification of the true nature and scope of the problem, and investigate allegations of employee misconduct. So again, we're still keeping it kind of general. We would never name an individual. So investigation allegations that Mr. Jones stole proprietary information. That's way too specific of an objective. We want to make sure that we're taking more of a general approach to it. Third element, to have a well-conceived strategy. So strategy is really focusing on the scope of the investigation, what do we need to look into, and what are the different methods of investigation that we can use, and how can we put all those methods together so that we can have the best investment of time and resources. So some of you may have attended a previous webinar where we talked about different methods of investigation. For those of you who haven't, just a quick overview. Here at Business Controls, we primarily use 6 different methods of investigation. There would be physical surveillance, electronic surveillance, research and audit, forensic analysis, undercover, and interviews. So some combination of those methods we're going to use when conducting an investigation. You want to think about how much money is it going to cost to use those particular methods? How much time are we going to have to be putting into it? What kind of internal resources do we have available to leverage versus external resources? And again, what's the time and money commitment when going on to external resources? Experienced investigators know that mapping a strategy prior to the start of the investigation will yield better and more predictable results. If you map out your strategy at the beginning, sometimes when you're getting in the investigation, you get in all the details, it can get confusing. Sometimes individuals we're interviewing can go off on tangents, and sometimes we follow those tangents. If you have a well-conceived strategy from the get-go, you can always take a step back, stop, and look at where you started. Look at what that original objective was, what the original scope was, and it'll help you get back on track. The best strategy is to have a process. We do refer to ours as the process of investigation. Our process is 7 phases, which we go through and how we collect our information and reach our conclusions. The fourth element is to use proper resources and expertise. So whether that be internal resources or external resources, you need to understand what kind of expertise that you have available and when it's important to rely on those expertise. So do you have sufficient resources? Do you have individuals that you can dedicate to conducting lengthier investigations? We do not ever want to have to switch investigators in the middle of a case. Certainly there are extraneous circumstances that may come up when you'd have to do that, but more typically we need to be able to assign an investigator based on excuse me, the time they have available to actually conduct a full investigation, as well as their expertise. It may or may not be appropriate for an individual in HR to be investigating a claim out of internal audit. HR individual may not have the skills required to conduct analysis of financial reports. On the other side, it may not make sense for a security professional to be conducting a sexual harassment investigation. Sexual harassment is employee relations. It's pretty a pretty sensitive topic, and you want to make sure that the individual you have interviewing people is going to be sensitive to the interviewees and has that skill and background to deal with those types of issues. So for your organization, you need to decide how you're going to assign those particular resources. Sometimes there are large corporations, so there's going to be an investigator for every kind of thing. You have a lead investigator for security, internal audit, compliance, HR, legal. Smaller organizations tend to rely on one HR individual, so an HR generalist is kind of responsible for the whole gamut of things. While that one individual is likely able to conduct a majority of those investigations, there may be times where something comes up that requires specific expertise. We encourage individuals to take an honest look at that. Failure to recognize the limits of one's abilities can compromise the investigation. So as professionals, we have to be able to recognize when something is maybe over our head or when we're not best suited to fully conduct the investigation. For myself, I use the example of the property management company that we're currently conducting a fraud investigation for. My background is not in accounting. My background is not in finance. I am not qualified to be reviewing those documents and drawing conclusions. Luckily, we have on staff a financial analyst who is a certified fraud investigator, so I rely on her to conduct all the document review and draw those conclusions. She can then provide me the information, and my expertise is more in interviewing techniques and speaking with individuals. So I can take that information and then use my expertise and resources to speak to the individual and ultimately, hopefully, get an admission. As external consultants, we do have the benefit of having those particular expertise in each of the areas. Sometimes internally with an organization you have it, sometimes not. So again, it's just about recognizing those differences and reaching out for help when you need it. Lastly, we want to make sure we have a lawful execution. Most people, I would like to think this goes without saying, but unfortunately it doesn't. We want to make sure that we're conducting all of our behaviors in the way we speak with individuals, in the way that we're gathering information in a lawful and ethical fashion. This also should be consistent with your company policies. So most companies are going to have policies that talk about lawful and ethical, moral behaviors and code of conduct, if you will. A fair test as far as ethics is if you're starting to question something you're doing, whether or not it's ethical, ask yourself, is this fair? Is it balanced? Is it necessary? Is this the only way I can go about getting the information? Or could I maybe gather it in a different manner which would be more ethical? Is this consistent with our organizational values? Nothing is worse than conducting an ethics investigation and being unethical in the way that you're gathering your information. So these are just some questions that are fair to ask yourself. Generally, if you're questioning whether or not something's ethical, that to me is usually enough to try and look for another option. One thing that has come up in our organization is pretexting. So it's when you call to try and get information under the guise of some other kind of information, of something that's completely false. So, for example, I'm trying to gather information about an individual at his previous place of employment. So maybe I call and pretend that I am a future employer where the employee has applied for a job, and I'm trying to get information to see whether or not they are a good applicant. that could be viewed as unethical in the sense that I'm misrepresenting myself to try and get the information. So that's a good example of when you would really want to think it through. Is there any other way I can get this information? Could I maybe contact the previous employer if you have that information and explain that you are conducting an internal investigation and heard that there were previous concerns there and ask if they're willing to share any information? I mean, that way you wouldn't be pretexting it and you could be really comfortable about the information you receive. Just remember that there are many different sources of information. Some sources are more ethical than others. If your investigations go to court, they are going to be looking at that. So they are going to be seeing how you gathered your information and will likely go after attacking that process. Here's some behaviors that we've identified as unethical and shouldn't be followed in investigative interviewing. We went over some of them and looking at the difference between the public and private sector. Mistreating the interviewee is definitely going to be unethical behavior. Using any kind of force or the threat of force. More importantly, the implied threat of force. You don't have to actually give a direct threat for someone to feel threatened. So it's important in how you word information and that you're always erring on the side of caution. Number 8, falsely imprisoning the interviewee or holding them against their will not only is unethical, but can lead to legal issues such as false imprisonment. In order to protect yourself against that potential claim, we recommend that you notify the interviewee that it is a voluntary conversation and that they are free to leave at any time. If your interviewee asks to take a break, to use the restroom or get some water, you always want to accommodate that break. You don't want them to have the perception that they can't leave that room. Never lock a door when they come in to be interviewed. It's okay to have the blinds down for confidentiality purposes and things like that, but you want to make sure that the interviewee has direct access to that door and that they feel they can get up and leave at any time. So you want to arrange the room such that they're closest to the door and there's nothing blocking them so they feel as if they can get up and leave. The determination of what constitutes ethical or unethical behavior is often driven by who is conducting the investigation. So this is that gray area. One could view a particular sentence or a comment made by an interviewer as unethical or maybe threatening, whereas the person making the statement would have a different perspective. So it's important to maintain that objective role and always be thinking about the impact that you might have on the interviewee. The last one, as far as unethical behavior, failing to treat the interviewee with dignity and respect. We always treat everyone we speak to with dignity and respect. And I know that I'm doing that because oftentimes it is amazing and very rewarding at the end of an investigation. You may be a little harsh, confrontational with an individual, and then obtain an admission. Nothing is more gratifying than at the end of that conversation for that subject to stand up and shake your hand and say, look, I appreciate what you're doing. I understand that you're doing a job, and I just appreciate the way that you came about it and how you treated me. It feels really good to be able to take that ethical approach, to be very positive in your interaction while still getting the information that you need. Lastly here, the last 10 minutes or so, I'm going to go over briefly how to properly document evidence and report those findings. So while the methods that we deploy and how we're interacting with individuals is going to directly influence the information that we receive, how we document that information is what the courts are also going to be looking at. So just because you said something happened isn't going to be enough. You're going to have to make sure that you properly document everything. First, I wanted to briefly touch on the chain of custody. Chain of custody is a term that's used to describe the identification and control of evidence. So basically, you're documenting your documentation. This can be applied to both criminal and civil cases. You want to be sure to document it from the first time you get that information until wherever it's going to be maintained. If you have a case that goes to court, you need to maintain that evidence indefinitely. So once you're put on notice that somebody is suing you or bringing something into the system, you need to be sure to have that information contained in a safe and secure place. When you are documenting the control of evidence, basically it's pretty simple. You just need to identify what the evidence is, so some kind of description. If it's a computer or a cell phone, you want to make sure to write down the model number or any kind of identifying serial number. If it's clothing or something like that, you want to provide any descriptors that you can to identify that piece of evidence. And then you just need to track the control of it. So it went from person A to person B. You want to be sure to write down the date that it switched custody, as well as the time, and then have people sign off on it. Yes, I gave this information or this evidence to this person, and then the secondary person is signing off, yes, I received this evidence. So it's just really tracking that information as it goes through. If you have evidence that is not properly documented, it's just going to put holes in the case. It's going to give the plaintiff's attorney an opportunity to place doubt in any information that you're sharing. So if you don't have something clearly tracked, it gives an opportunity to say that the information may have been compromised, or perhaps something did something to the evidence to make it look more favorable to the employer. As I've discussed in previous webinars, when you're conducting an investigation, generally they're not going to go after you based on your findings. They're going to nail you for your process. So they're going to look for holes in your process and go after that and say, well, if they didn't get this part of the process right, then how can we rely on their findings? So if you can't manage to properly document evidence, how can they trust that the conclusions you've reached are legitimate? So that's why it's important to really have this evidence handling down. Reporting findings. Most of the times our investigations are going to end in some kind of written report. Typically, this is going to be accomplished using a case file. You can choose to have a hard copy of a case file. You can choose an electronic copy of a case file. There generally will always be some kind of hard copy form to the case file because it's going to contain information such as interview summaries or evidence that you can't just save over as an electronic copy. If you have something that is an original, you need to save that in original hard copy form to ensure that you are following the rules of best evidence and have that information to present if it ever goes to court. There are a lot of different ways to document the information. I like to use electronic because then you don't have to physically be wherever those files are to gather information. You can pull it off a system. It's easy access, and it allows multiple people to have access to the information. There are several solutions I have listed on this slide that organizations use as far as to document an electronic case file and then even taking it further to case management. Our organization, Business Controls, does own and operate MySafe Workplace, which is not only incident reporting but is a case management system. And so when we get cases in, we'll actually put that information into our case management system, and we'll continue to document the case along the way. So I'll literally be logging in the electronic system, conducted interview of person X on this date at this time. When we get to the end, we're going to actually upload our report to that system. We'll document any disciplinary action or any follow-up that was needed. So it literally is a complete timeline of our investigation. The case management feature is helpful for organizations that have multiple individuals conducting investigations. So I can go into the system as a manager of our team, and I can see what everyone's working on, and I can have immediate insight into where they are. So I can look at my one investigator and see where they are in their case. Have they completed interviews? Are they writing reports? And make sure that they are keeping up with where they need to be without even having a conversation. Of course, if there are any questions, you always want to follow up with that investigator. Here's some information that we recommend including in your case files. So activity log, that's talking about reviewing documentation, whether you requested background information, looking at policies, any kind of request for information, as well as actual interviews. So you want to log when those interviews are being conducted and when any follow-up is necessary. Generally, there's some clerical or administration sections, so you know, that applies most commonly to us as a third party because we're having to vet out, you know, who our point of contact are and things like that, but that also can apply internally so that you guys understand the chain of command and where the information is supposed to go, identifying the decision makers versus the fact finders. Any kind of notes or work products should always be maintained. So even when you're writing out an outline of investigation, or maybe you're preparing for an interview and outlining some questions that you want to ask, I always save that information. It's all evidence. And 5 years from now, when the court case comes up, I'm not going to remember what questions I chose to ask or why I chose them. But if I have my notes and my outlines, it's going to go a long way in refreshing my memory and what I need to share. Lastly, reports and communications section, so actually having the full written report or any kind of information that supports that report, whether that be exhibits or any of the administrative information that you've gathered. Reports we do recommend that you are documenting everything in a final written report. I will be the first person to say that I hate writing reports. I never thought that I would be in a job that would require me to do so much writing, but it is so important that we are documenting every step of the way, documenting how we got to our conclusion and all the information that we've gathered. The reports do need to be clear, concise, informative, and complete. You need to completely outline your process and how you reached your conclusions. Some common mistakes made by report writers include a poor understanding of the facts or the topics, that it's disorganized or doesn't have any kind of logical flow to it, communicating in the wrong language, or failure to meet the needs or expectations of the reader. It's important to know who is going to read this report so you understand what kind of information needs to be contained within it. You also want to communicate in the appropriate language. So you want to be using language that is familiar to that industry. Don't put your own spin on it. With you guys mostly being internal investigators, that should come pretty naturally. But something generally referred to would be something as simple as time. So using military time versus not. We try to report in, again, whatever time the organization used or whatever time their information is being reported in. A couple of tips when writing reports: be sure to select the correct voice. We always write our reports in third person, so it's BCI or this investigator determined. We don't ever write in the first person, no I's used or any of that in the report. Always want to augment our finding with exhibits. So if we're going to refer to maybe the employee was involved in some previous investigation and received discipline, yeah, I want to make sure that I'm writing that in the report, but I'm also going to include an exhibit of that discipline as support for some of my findings. So maybe they're in trouble again for similar behavior. Well, if they've already been disciplined for that kind of behavior in the past, and I can show that, that's going to support my conclusion that they've engaged in the similar behavior. Begin with the template. You should have a general template to follow when writing reports, but know that you should be flexible and you're going to have to switch it up according to what you need. So sometimes you need to write out full interview summaries of every person you spoke to. Other times it may not be necessary and you only have to pull out information that's relevant to the actual investigation. So you have to look at every investigation separately and say what is important information and what do we need to have included. For example, we have a typical template that we follow. I have an investigation that I'm actually writing up right now that is going quite away from that typical template that we use. It's not important that I'm writing up all the individual interview summaries, but what is important is that I'm clearly documenting how we identified the subject that we believed was responsible for taking the material out of the company. It is important to vet out all of your investigative process and that you're clearly documenting it. Again, when you get called to court, it's going to be 5 years down the road, 2 years down the road, and you're not going to remember everything that you did or why you followed that process. So it should be clearly exhibited in your report. Include a conclusion, so general findings, but only provide recommendations in writing if asked. Try to stay away from putting recommendations in writing. The reason we say that is because if you make a recommendation in writing and it is not followed, you are creating liability for your organization. If you must write a recommendation in writing, it is important that you put something in there, say, you know, this recommendation is based on limited information that was gathered during the course of the investigation and does not take into account business needs or things like that, so that you're kind of giving your company an out. So if they don't follow that particular recommendation, they're going to be able to say, well, yes, that was the recommendation, but this is why we didn't follow it. Here's just a few elements of the report that you can or cannot include. So these are just some titles that we have on our template. Again, we don't include all this information in every single one. A timeline could be completely irrelevant. Sometimes timelines are what ties everything together. So you just have to figure out what's going to work best, but always include any enclosures or exhibits to support those findings and conclusions. All right, so I'm just about bumping up at the end of time here. What about 45 minutes in the content? So now is an opportunity for any questions. So, all right. So one question, are there complaints that should not be investigated by an employer? So I assume this is referring to, are there specific occasions when it should be outsourced? Absolutely, yes. We recommend that you are looking at a third party to help you out in a couple different circumstances. First, if it's above your expertise. So if it's something that you don't think you have the proper skill or experience, to go ahead and look for somebody who has expertise in that area. Also, if it's somebody within your own department or someone that you as the investigator report to or are responsible for reporting information to is being accused, there may be a conflict of interest. So for example, typically HR is conducting a lot of the investigation. What happens when you have a C-level or executive employee who's being accused of something? While HR may not have a direct report, there certainly is going to be a dotted line to that executive level. So there may be a conflict of interest or potential bias. Now, while you as the investigator may be fully capable of conducting an objective investigation, you have to think of the impact or how other people may be viewing that. So particularly if it's your direct report, the investigator should not be conducting that investigation. Another question, should a complaint be handled differently than a grievance? Yeah, I mean, and that's going to be outlined according to the contract with the union. So, you know, depending on what the complaint is, it's going to have to go through a different process. So if someone is grieving say a disciplinary action, there's not going to be you're not going to follow the same process that you would follow if, for example, when you come to that conclusion of the disciplinary action. So you want to be sure to separate the two, but when you're responding to a grievance, hopefully you've done your due diligence in the original investigation to support the conclusions that you've made, and ideally you should just be able to recreate the report or the process that you followed in order to articulate why you got to the decision you did. There may be a need for some additional investigation, but again, hopefully if we did it right the first time, then that's going to be enough information to push you through that grievance process. Is there a time frame an internal investigation should be kept to? Yes, but can I tell you a number? No. So we have a duty to respond to all complaints in a timely manner. So what is in a timely manner? That means in a reasonable manner. So what does reasonable mean? So generally speaking, rule of thumb, you should be responding to your complaining party within 48 to 72 hours of them making the complaint. So responding to that individual is as simple as saying, hey, we received your complaint, we're looking into it, we will be reaching out to you for more information. That's enough to do initially. So you're letting them know that you have it, you're on it, and you're going to start the investigative process. We try to wrap up all of our investigations within 2 weeks is what I like to try and keep it under. So that's from start to finish. Now, there are many hiccups that can happen in the process. Say you need to interview somebody and they're out on leave. You can't require them to speak to you while you're out on leave, and maybe they are the only witness to an incident. So you have to wait until they come back to get that information. So there can be delays to your process, and that's okay as long as you can articulate what those delays are. Be sure to document if you're going to have any delays. I know as an external investigator, we often get delays when we're working with internal folks and requesting documents. So you say, hey, before we get started or get on site, I need to look at this policy. I need to look at this person's personnel file. I need to review badge access information. We'll make a variety of requests. Well, it could take a week for everyone to get all that information together, for me to look at it and then analyze it to determine who I need to interview. And that's okay, again, as long as we're documenting this is when I made the request, and here's the information, and we're following up in a timely manner so that I'm not just letting it go. I would never wait a month for someone to get me information and then say, oh yeah, what about that stuff? No, after a couple of days, I would be constantly following up. Hey, do you have that information? When do you think we might get it? So again, generally speaking, I try to keep it under 2 weeks. Most should be able to be wrapped up in a couple of days, but of course there will be exceptions to that. Very good question. So once the investigation is completed, how long should the organization keep it on file? So retention of records. There is technically no set number of years for how long you have to keep internal investigative records. If you talk, I would first and foremost, before I continue with this conversation, go to your legal counsel. Go to your internal counsel or go to your external employment law counsel and see what they recommend, and I would go off with whatever time frame they recommend. Rule of thumb is generally to keep it about 5 to 7 years. We keep all of our files and records for 7 years. Again, like I stated earlier, if you have anything that has gone to litigation, or if you have been placed on notice that something may go to litigation, or there's any kind of demand letter for information, you must maintain that information forever. So you've got to keep it on file, and the reason you have to keep it for indefinitely is because of the appeal process. So once you get put on that notice, put it somewhere safe and never go back to it. All right, another question is about the chain of custody. Are there different rules depending on who the evidence is being passed to and the time frame that people have it? So generally, no. So is there a difference if you're passing evidence interorganizational, so among employees, versus going to an external source? No. You need to be documenting it just the same. So when it goes from employee to employee, we still want to write that information down. We still want to document it. I don't care if you're going to have it for 5 minutes while you're the delivery boy sending it to somebody else. We still need to have that time frame documented so that somebody can go back and track each person that touched that piece of evidence. So no matter who it is or what the time frames are, we need to make sure that we're having it all documented equally. All right. Are there circumstances where discipline that goes against past practice becomes okay? Absolutely. So we generally will follow past practice and policies when making disciplinary or termination or corrective action decisions. Just because you did something one way in the past does not mean you have to do it exactly the same in the current situation, as long as you can articulate the difference. So for example, say you had a tenured employee in the past, somebody who'd worked there about 25 years, who engaged in some general misconduct, had some exchange of words that were perhaps perceived by one individual as threatening. You conducted an investigation, determined that it was perhaps a slight misrepresentation. Both employees fully acknowledged that they contributed to the disruption, and maybe you did some corrective action or some verbal or written discipline. Now, recently, you have somebody else who engages in threatening behavior. Maybe they made a direct threat, and this employee has only been with the company for 60 days. You absolutely can determine that because this person has been there for such a short period of time, maybe they're in a probationary period, you can opt for termination. Just because you didn't do termination before doesn't mean you can't do it now, as long as you can make the argument that this person was in their probationary period. Not only do they have this one incident where they were threatening this individual, we've also had other people come forward with additional examples. This is not an isolated incident. Those are the types of things that you want to document to support you going against your past practice. So always acceptable as long as you can document it and support. All right, I think we're hitting up on the time, so just to be respectful of your time, we'll go ahead and end the webinar. If you guys have any additional questions, feel free to continue sending them through. I absolutely will follow up on an individual basis. If you have any needs for consultation or any questions about a particular internal investigation, we'd be happy to help you out, consult. Even sometimes you just need to bounce some ideas off someone, make sure you're on the right track. Feel free to reach out to me directly. Head to our website to get additional information, some guidelines, white papers, things like that. I really appreciate your time today. Again, would love any kind of feedback that you have and would encourage you to participate in the post-webinar survey. And we will be sending out the presentation materials here in the next couple of days. Thank you for your time and have a great week.